I'd like to welcome each of you this morning, and I'm just so glad that all of you were able to make it on this cold morning. My brother's here from Ohio, Jamie, and he says it's like 11 below up there. What was it?
It was last week, 11 below zero.
Yeah, so he's really happy to be visiting and playing golf today after this meeting. This is our anniversary month. January 3rd last year is when we started Construction Zone, so we've come a long way, and I'm just so glad that all of you could come and be here. All right, at this time, I wanted to share with you because we've been doing this for a year, and people still don't know the different types of membership. There's only two, and on your table there's a list of guest speakers for this year. A couple of them we haven't firmed up, but we've got quite a few listed here, and Philip over here, who introduced himself earlier. He's going to be our guest speaker on April the 17th, and I'm looking forward to that presentation. And if you're a hub vendor or a hub contractor, please give him your card because he needs, hubs to work on their projects. And then on the back side of this that y'all can take with you, there's two types of memberships for Construction Zone. One is the professional service provider, and the other is the client member. If you just want to sign up and join, it doesn't cost anything. You just go on the website, go to constructionzone.co, not COM, because there's a lot of others that are COM, just constructionzone.co, and click join here, and you can, it gives you the option to join as a professional service provider or client member. If you just want to provide your services and not be real active, but just have your name up there as a valued business that wants to do business with somebody else or a client member that goes on the website, that's what you do. It takes less than 5 minutes. You put your name, your address, your website, and what you do. And then if a client member who pays $20.14 goes on our website, he can view, or she can view, all the members, all the professional service providers. And Construction Zone is a one-stop shop. So if somebody's out there and they don't know what contractor to use, they have a building they want to build or a space they want to finish out, they can go to the Construction Zone website, and by paying $20.14 per year, I'm keeping it simple and keeping it inexpensive, they can view all the professional service providers that have signed up and said, this is what I do. And we're not limiting this to just Construction Zone people. We have some real estate people in here, which they are related to construction, but also insurance agents, and just, we're not limiting to any. What we are limiting Construction Zone to are to companies that bring value, that have a best service, and they have integrity, and they do quality work. And those are the people that Construction Zone wants. And would the board members that are here please stand up? I know we have Daryl and Jim and Stephanie, all the board members, and Charles Gates and Dar Miller and Joe Bagley. Anyway, these are our board members, and they will be reviewing. You can sit down now. They will be reviewing at our monthly board meetings all the new members that sign up, because you all know, as well as I do, in the industry that you're in, you know the people that are good, and you know that the people that aren't so good. And so we're going to try to eliminate anybody that's not so good, because we don't want anybody going to our website and using a company that we're saying is a good quality company that is not. So we're going to be reviewing these names monthly as people sign up, and we have about 125 on the website now, just to make sure that we do just have quality members. So besides being a member, you can also come to our monthly breakfasts and network and meet other people that you might be able to partner with. I know a number of you all here today. At RJ Cotter, we're doing a project. Daryl Klecka, we're doing a project together. I've used Jim Montgomery, and Stephanie has been very helpful. And Tom Whitney, he's my bonding guy here. And then Susan, she does all of my stuff. And they normally don't video small things like this. They do commercials, and they're great with doing CDs on your company, so if you ever need a company to do that. And I've known her for so many years that's why she's doing this for me. And thank you, and I love you. Okay. But at our monthly breakfasts, you also, like today, lien and construction laws. I mean, as Stephanie said earlier, these change every other year. It's like, okay, now we got to do something different because this doesn't work and it's broken. So now we're going to have a new law and a new regulation on how to do liens and all of that. So she's going to update us this today and tell us all about the latest and greatest on lien law. So I'm glad that she's here and is going to educate us. So that's what Construction Zone is all about. It's about developing you, developing your business. We're not here to raise funds or, you know, we're here for business. We're here to make money. We're here to profit. This is a for-profit organization. It's not a nonprofit. And if you're also, I failed to mention, if you're a client member and you sign up and pay $20.14, this enables you to refer clients. And I know there's several people here that have contracts now because they were referred by somebody in Construction Zone. And if you pay the $20.14, you're able to use this service. And if you refer somebody, then just a small 1% fee is what you're expected to pay if you get a job. And you don't have to pay it until you get the job and you collect the money. If you never collect money, then you never owe anything. So it's not about pay up front or whatever. It's people, it's other businesses helping businesses. And you get a little bonus by going through Construction Zone. So if you get a job, and today we're going to have a presentation for the first check that's going to be presented, and I'm going to do that a little later in the program. I'm all excited about that because the job was referred to me, Kegley Incorporated, and so I got my first draw, and so this check is just one of the other checks that are going to come. As I get paid on this particular contract, 1% goes to Construction Zone, and half of that 1% stays with Construction Zone to pay for all of you that had free breakfasts this morning and for the setup and for the different expenses for Construction Zone. And then the other 0.5% goes to whoever referred. And so right now, if you have a referral and we're having a few issues again with the website. I wish you could get a website and not have to worry about everybody hacking it. But obviously somebody hacked my website, and so I'm going to a different host, and it's just a little process. It'll be fixed, shortly. But until then, if you have a referral and you want to run it through Construction Zone, just email me that, and then we'll follow up with that. Just tell us who it is, and if there is somebody you want to refer specifically in our group, or if you don't know, then we will help you find somebody. So anyway, I wrote this all out on a piece of paper, so if I talk too fast, you have it, and you can, also this is on the website, so if you go on the website to constructionzone.co, you can find out this information and read it again and look at it. Also on your table is a card like this, and this just has the benefits of being a member, or if, concept to completion. If someone, needs any of the services, they can go to Construction Zone and find the right person. So at this time, I'd like to introduce our guest speaker for today. And I am, she's on the board, and I didn't even know all this stuff about her. I'm just glad that I'm getting to introduce her. But Stephanie O'Rourke is a member of the firm's litigation practice group. She graduated St. Mary's University in 1988 and the University of South Carolina with her BA in 1984. She was named to the Thomson Reuters Texas Super Lawyers list as one of the top attorneys in the state in not only in 2012 but also in 2013. That's really great. She was named by her peers as one of San Antonio's best lawyers in, again, 2010, 2012, 2013 by the Scene magazine. She was named 2010 Industry Professional of the Year by the Associated Builders and Contractors. She AV rated by the Martindale-Hubbell Peer Review, the highest rating possible. She has memberships and affiliations with the San Antonio Bar Association, the Kendall County Bar Association, the State Bar Association, the Texas Association of Defense Criminals, Defense Research Institute San Antonio Construction Law Section, Government Affairs Committee for the Association Builders and Contractors. And I didn't know this. This is something dear to my heart, that she's also a member of the National Association of Women in Construction. And I used to be real active in that organization starting in 1979. So don't count the years so you figure out how old I am. But anyway, South Texas Deer Association, I'm not for sure about that one. But Board of Directors for Port Royal Ocean Resort, and then also Board of the Construction Zone. So I'd like to present Stephanie O'Rourke.
All right, before I start, I want to kind of get an idea of our audience here. I know everybody went around and kind of introduced themselves, but let me have a showing of hands for general contractors. All right, how about subcontractors, first tier? All right, second tier subcontractors, suppliers. All right, and what about architects? Engineers? All right, well, I think I'm going to hit across the board on some subjects that are going to be near and dear to everybody's heart. The first area that I want to go over is just basically your lien basics. How to file a mechanics lien, what are the statutory requirements, and what are the notification requirements. The second area that I want to talk about is the anti-indemnity statute that came into play in 2012, which essentially did a total overhaul of our indemnity laws in Texas. And then the third area is 2 cases are pending in front of the Supreme Court that have to deal with design professionals, architects and engineers. With that said, I'm going to go ahead and go into our lien basics. I think as everyone knows in this room, mechanics and materialman's lien are not easy in Texas. Texas is actually the most complicated state for filing a lien. We have 2 types of liens. We have statutory liens and we have constitutional liens. As far as the statutory liens, you have certain notification requirements. If you fail to adhere to the notification requirements, your lien will be deemed to be invalid. If you have an invalid lien on a property, you are subject to any cost, fees, and attorney's fees that the person removing the lien may incur. So it's really important to make sure your lien is valid before you file it. So that means complying strictly with the statutory requirements. Now, the first type of lien that I want to go into is what we call a constitutional lien. The constitutional lien was actually the first lien that you could ever file in the state of Texas. The importance of the constitutional lien is if you miss your deadlines on a statutory lien, and if you are an original contractor, you have 4 years still to file your constitutional lien. Now, a lot of people don't know that, and so if you miss your 4-month deadline, which I'm going to get into the deadlines, you always have this to fall back on. Now, the downfall with the constitutional lien is, number 1, it's only for an original contractor. Number 2, it only attaches to the building. So if you did site work or if you did utility work or anything like that, it's not going to attach. So it's only if you did work on the building itself and if you have a direct contract with the owner. Now, the other good thing about a constitutional lien, it's self-executed. You don't have to do anything. You don't have to go and file that lien down in the courthouse, but you got to file the lien to have notification to others. So while it may be self-executing and it's automatic lien for you, you really need to go ahead and file your lien affidavit, send it down to the courthouse, file it in the county court records, send it to all parties that need to have notification. This way, if somebody goes to buy the property, the lien is there, everybody else is on notice, so you don't have the good faith purchaser situation. I love this little picture, I thought it was great. Now again, on the constitutional lien, only original contractors entitled to have it. Subcontractor, sorry, you don't get the constitutional lien. Now, the next type of lien I want to talk about is the statutory lien. The statutory lien is found in the property code. The statutory lien allows a subcontractor, a supplier, an original contractor, architects, engineers to have a lien on not only the building, but on the land. Now, if you're working on a leasehold estate, it does not attach to the building and the land. It only attaches to the leasehold itself, which you have to be very careful of because if you attach it to the entire property, your lien could be deemed invalid. Now, statutory liens have very strict requirements as far as notification. So what we have is we usually have our 3 tiers. We have our contractor, we have our subcontractor who's in direct privity with the original contractor, and then we have our second tier lien claimant, which is your subcontractor, who's usually a supplier to the subcontractor. Depending on where you fall in that chain is going to make the determination of the notification requirements that you have. Now, your lien deadline is determined upon your accrual of indebtedness. So if I am the general contractor my lien runs from basically a different deadline than my subcontractor or my subcontractor. So it's really easy for a general contractor. Your lien's gonna run from the time that your contract is terminated, it's completed, or it's abandoned. So for you, what you need to remember is always, when your contract's done, you've gotta file it the 15th day of the 4th month after that deadline. If you don't file it by the 15th of that 4th month, you're gonna have to fall back on your constitutional lien. Now, for a subcontractor, it gets a little bit more difficult. Your accrual of indebtedness runs from the time period of when you actually do the work. Okay, so it's every month that you do that work. So many people do it from your invoice date. I'm telling you, if you do it from your invoice date, your lien's not gonna be valid. You have to do it from when you did the work. So, if you did your work first to your subcontractor, so you got a contract directly with the original contract, you did your work in January, your first notification is going to be in April, okay? So as a first-tier subcontractor, you have a 3-month deadline. So on or before the 15th day of the 3rd month, which would be April, you have to send your notification to the owner and the GC. I have not been paid. It's a real simple form that you have to do, but basically it's a notification. I haven't been paid. Owner, don't pay the general contractor. And then you have until the 15th day of the 4th month to file your lien. Second-tier subcontractors have a little bit more difficult time. They have what we call the 2nd month notice and the 3rd month notice. So if you have a contract with a subcontractor, then what you have to do is on or before the 15th day of the 2nd month. So if you perform work in January, in March, you have to send notification to owner and general contractor, I haven't been paid, then you've got to send another notice the 3rd month, and then file your lien the 4th month. So 2nd month, 3rd month, 4th month. The key with the 2nd tier is you've got to send that 2nd month notice. If you fail to send the 2nd month notice, your lien will not be valid. The courts are real lenient on the form of the 2nd month notice, but you have to send notification. And really it makes sense. The purpose of the notification is to have that owner trap the funds. So they don't go and have, pay out their retainage to the general contractor or otherwise. Now, as far as notice of filing the lien affidavit. So let's just say I'm a 2nd-tier subcontractor or a 3rd tier, and I file my 2nd and 3rd month notice, and I get to my 4th month. I've got to file my affidavit, and I file it in the county court records where the project is located. You have got to do this by certified mail, and it has to be on or before the 15th day. So let's just say I file it on the 16th day on the 4th month. Lien's invalid. Always make sure you keep your certified receipts. If you're receiving the lien, keep that envelope because it could make the determination as to whether or not that lien is valid or invalid. You have to send that lien after you record it on the 5th business day after the filing. If you do not do that, again, your lien could be deemed to be invalid. So, again, very complicated laws. So you have to make sure, send it by certified mail before the 15th day, and get it to owner, general contractor in that time period, and then you'll be fine. Now, as far as the form of what you have to have in your affidavit, the statute is pretty clear, but again, if you don't follow the statute and you don't have everything contained within the affidavit itself, you could be deemed to have an invalid lien. So the form of what's required is set out in the property code in section 53, and really you can go online and find these, but it's a sworn statement of the amount of the claim. And the biggest thing that the courts look at is it's got to be sworn to. If it's not sworn to, they will throw that out automatically. Everything else kind of courts have looked at as substantial compliance test. So you've got to have the name and last known address of the owner, a general statement of the kind of work done and materials furnished, the name of the person who furnished the claimant with the materials, the name and address of the original contractor, and a description legally sufficient for identification of the property sought to be charged, and the claimant's mailing and physical address. So again, you know, some of these things the courts are lenient on, most of them, they're not. You've got to have compliance, or the courts will say it's not valid, we need to throw it out. And the reason, because it's just notification requirements. They want everybody to make sure everybody's clear on the notice that's been given. Retainage. I think the retainage affidavit is probably the most complicated as to when it runs from, because it's a different deadline than your basic liens. You know, your basic liens, always remember the 4th month, you know, as far as the affidavit itself. But your lien against retainage, your notification deadlines are very complicated, and your filing deadline runs from a different date. So if you are the original contractor, the first deadline that you have to remember, if the owner files the affidavit of completion and sends a copy to the general contractor, then you have 40 days to file your lien. If they file a notice relating to termination or abandonment of the contract, so if the general contractor is abandoning the contract, or if he's terminated, again, you have 40 days. Now, if the owner sends a different notice, which is, contractor, I want you to go ahead and file the notification that you're completed, then it's a 30-day deadline. Complicated, I don't know why they did it this way. Just remember, if you get that notification from the owner saying, contractor, your contract's done, it's 40 days. If he asks you to go ahead and file the notification of completion, it's 30 days. Now, if the subcontractor sends his notification properly, it will trap the funds in the hands of the owner. And just remember, if you're the owner, if you get a trapping notice, do not release those funds, because then you will be liable over and above that amount if you pay him out. How many people are familiar with the law that came into effect about a year ago, what we call the anti-indemnity law? I know Tom is. All right. Before January of 2012, the indemnity laws in the state of Texas really were all over the board. We had 3 types of indemnity. The first type of indemnity you had was what we call the broad form indemnity, wherein I asked you, let's just say it was a general contractor-subcontractor relationship. I, as the general, asked my subcontractor to indemnify me for everything in the entire world, including my sole acts of negligence. So if something happened on a project where I was negligent or grossly negligent, and I caused the accident, and I had this indemnity provision with the subcontractor, we get in a lawsuit, subcontractor, that indemnity was in there, would have to indemnify me. The second type of indemnity was what we call the limited indemnity, which was essentially, I would agree to indemnify you, Mr. General Contractor, for just my limited acts of negligence, and you would agree to take over your acts of negligence in the event there's a lawsuit. And the last one we had was basically everybody agrees to indemnify each other for their acts of negligence. The legislature decided the laws for indemnity were way too complicated. Too many lawsuits, too many things for everybody to remember, too many technicalities. So in 2012, the new indemnity law came into effect. And the new indemnity law basically says everybody's responsible for their own acts of negligence. So if I do something on the project, then it's my proportionate share of negligence I'm responsible for. Subcontractor, you're responsible for your own proportionate share of negligence. Owner, you're responsible for your own proportionate share of negligence. So this way it was going to be fair across the board. Now, it only applies in certain situations. So it doesn't apply to every contract. It's only going to apply in construction contracts where you have either a SIP program, which is a contractor's insured control program, or you're procuring property and casualty insurance. Now, the definition of a construction contract, though, is a little bit broader. Really, it's going to apply to any contract on that site. So if you're an engineer, if you're an architect, if you're a supplier, owner, manager, general contractor, subcontractor, the anti-indemnity statute is going to apply to you. If you don't adhere with the anti-indemnity statute, your contract is void. It's going to apply for private or public, demolition, excavation, design contracts, performance bonds, assignment agreements. What's prohibited? requiring another party to indemnify you for your sole acts of negligence. So it's void now. You can't do it except the employee exception. So the courts and the legislature decided, you know, really, we're going to have an exception to this anti-indemnity being across the board and being easy. So we're going to have this employee exception. And what the employee exception is, it will allow the broad form of indemnity that we talked about in one area, and that is when the employee's injured, he sues the general contractor, he sues all the subcontractors on the site, and the courts in that situation have said, you know what, we're going to allow that broad form of indemnity, and the reason why is because, let's just say it was a subcontractor's employee. You have control over your employees, or you should. And so in that situation, if it's the employee that's suing, then the court is going to allow that broad form of indemnity between the subcontractor and the general contractor. General contractor will have the right to have the indemnity back against the sub in the event that he is sued. Let me kind of go back. If the subcontractor's employee sues the general contractor, and I've got the employee exception in my contract that allows the indemnity on the employee situation only, the courts will uphold that. Mr. Subcontractor's employee sues the general contractor can go back to the subcontractor and say, you indemnify me for everything, even if I caused the accident. A little unfair. I know, that's why it's important to know this. It's a little unfair, but again, what they're looking at is that subcontractor should have controlled his employee on the site. Should have been adhering to the safety, and even if I have any part of it, that full indemnity is going to be valid. So what does the clause look like? This is the general indemnity clause. You need to have that in your contracts. So if you are owner or the general contractor, or if you're a sub that has a sub under you, you need to make sure you have this because it is important and it is valid. It's the only time the broad form of indemnity is valid anymore. All right, these are the two cases that are pending in front of the Supreme Court right now. We are actually anticipating that we may have a ruling tomorrow on these. I think everybody kind of knows the basic premise of law that if I don't have a contract with you, I can't be sued because there's no privity. Well, our wonderful plaintiffs bar, as Jim probably knows this, has gotten very creative over the years. With tort reform, they have to look for new places to sue. And so they came up with some ideas of, you know what, the architects and the engineers are always the ones that, you know, have designed this project, and the design is wrong, but, you know, I don't have a contract with them. I'm the subcontractor. I don't have a contract with them. Only the owner does. General doesn't have it either. How can I sue them? How can I get to them? Negligent misrepresentation. So the courts have been struggling with this concept of negligent misrepresentation for a couple years now. And the cases are really all across the board because they're holding two things. Number one, there's no privity of contract. And number two, well, then they should be limited. It should be limited to the actual contract value itself. Well, there was two cases that have come down, which are these two right here, which allowed the contractor to sue the architect in one situation and the contractor to sue the engineer in another situation based upon this theory of negligent misrepresentation. And what the court said is it doesn't really matter if you didn't have a contract with them. That architect or that engineer certified those plans as being good. They put their stamp on them, they made the representation that the project could be built in accordance with these plans, and therefore we're going to allow this theory of negligent misrepresentation to go forward. But the damages are going to be a little bit different. The damages aren't going to be the value of the contract. The damages are going to be the cost that actually the contractor or the subcontractor incurred as a result of that negligent misrepresentation. So for example, in one of these cases, it was a tech stock project, and the architect or the engineer had certified that the plans were complete, that the project would be built according to those plans, and as a result, plans were given to the contractor to bid. He bid the project, He built the project, but lo and behold, all the water started running off on the project, built up silt. Contractor to come in and spend about $5 million in removing all that silt before the owner would accept the project. Contractor sued the engineer saying defective plans. You had put a stamp on these plans saying that the plans could be built, or the project could be built in accordance with these plans. Look what happened. The court allowed the contractor to recover his $5 million because there was that stamp on there saying the project could be built in accordance with this engineer seal, the plans are great. So the court now is facing the issue of, all right, two things. Number one, what is a negligent misrepresentation in order to allow a case like this to go forward? And what the courts have kind of struggled with and what's in front of the Supreme Court right now is that the definition of a negligent misrepresentation is supplying false information for the guidance of others, or significantly the sort of false information contemplated in a negligent misrepresentation case is a misstatement of existing fact. Either one of those will get a negligent misrepresentation submission to the jury. The damages are going to be any damages that is caused as a result of that negligent misrepresentation. In other words, any of the contractor or subcontractors' direct damages incurred because of the defective plans or defective drawings. So we anticipate any time now we should have a decision on those two cases. I think that the decision is going to be that the negligent misrepresentation claims against architects and engineers will stand, unfortunately. That is it for me, and if anybody has any questions on liens or anything else, just let me know, and I'll be here for a little while, or you've got my card. You're so sweet. Thank you.
I appreciate it.
Hey, thank you. That was very nice of you.
Thank you. You know, I appreciate Stephanie coming today. That was very informative for me and helped me just keep me updated. And I had told Stephanie one time, I hope I never need her, but I really do need her to help keep me in line so that I don't need her for the big stuff. So anyway, there are additional handouts there at the front. If you didn't pick one up when you came in, please pick one up on the way. Now for the important part of this meeting. I'm so glad Bill Willer came. And Bill and I go back, I don't know, 10 years or whatever, I don't know. But I'm so thankful that he recommended my company to do a job at Nelson Garden Landfill. And we feverishly, the project went on for like 3 years and it wasn't funded and they were going to scrap it. And I don't know if y'all are familiar with the Nelson Road Guard projects, but a company out of Liverpool, New York, Edgewater, bid on reclaiming the methane gas at the Nelson Garden landfills. And they needed to get funding, and for like 3 years they had to go through all these, regulations, get all these permits and blah, blah, blah. And so at the 11th hour, they thought that, they weren't going to be able, after 3 years of trying to get funding, and y'all know what the industry has been the last 3 years, they just didn't have the funding. And then in October, they decided that they finally got funding. Well, it wasn't they decided, they finally got it. It came through. So they had to, in just a couple of months, build these buildings. And so they didn't have time to get bids and all this kind of stuff. And he had recommended me 3 years ago. And he said, they said, well, Anita, we need these 2 buildings built in 30 days. So they had 30-foot columns, piers that went 30 feet down in the ground. And we just had to get the shell of the building. So in like 3 weeks' time, I did all of this, and they were just very grateful. They were very glad that Bill recommended me. And so if I could get my son, Matthew, will you please stand up? He came in a little bit late, but this is my son, Matthew Kegley. He's working on his graduate classes and was in class till 10 o'clock last night. So I excuse him for being a little bit late. And Jamie, my brother, can you help unveil this? Yep. And Bill, if you could come up here. So this is the very first, and I'm only going to do this, hold on just one second. I'm only going to do this check presentation one time and tell you what the referral fee is. And like I said, he'll get this check today, and then next month when I get paid again, he'll get another check, half of 1% each month until the job is done. So, Bill, I appreciate this and unveil this. So, here you go.
I met Anita, it was 9 years ago.
Okay.
And even that seems like it was just yesterday, but I met Anita when I leased office space from her in her building to house my newly formed company. And I think I stayed in your space, in your building for about 4.5 years or so.
Yeah.
And so after writing all those rent checks every month, I'm glad to get one. So thank you very much.
Thank you so much. Okay.
By the
so-
way, that project is a very interesting project. I don't want to take too much time, but this company out of New York operates a few of these sites. And I got to know them many years ago, but they actually drill wells in the landfill to reclaim the methane gases generated by the decomposition of the trash, if you will. And they scrub it and they burn it in reciprocating engines and turn generators and provide electricity. This project will sell the electricity to CPS Energy. So it's a very interesting project. Good luck with it.
Okay, thank you. And the other thing too is that, I don't know if y'all know, but, you know, they're selling this methane gas after they scrub and clean and all that back to CPS. And CPS is we have one of the lowest rates in the nation. CPS, the electricity charges that they charge us. So, you know, this is just part of them keeping their rates low. So anyway, this concludes our meeting, and we have several of us that are gonna play golf. If you wanna play golf after, I have a special rate, with the Dominion, and there's several of us that's gonna play. I'm gonna change my boots and, so thank you again for coming and participating in this.